Good day, Crime Talk aficionados. It's Saturday. So what does that mean? It means one thing. It's the Crime Talk weekly recap of all of the top stories. So if you missed any episode throughout the week, now is your time to get caught up. Thanks for watching. Have a wonderful day, and we'll see you next time on Crime Talk. All right, first on the docket. This is huge. Now, this motion was filed Friday, but it was just made public today. That's right. The government, the prosecutors in the Lori Vallo matter do not contest that she is not competent to proceed. That's right. The government confesses the motion, withdraws its contest of that hearing, and basically Lori Vallo is found not competent to proceed. Let's take a look. This case has gone on now for over a year, and not much has taken place. Lori Vallo wasn't at any of the hearings. Everything kind of kept getting delayed, and no one really knew why. It was never made public that a competency evaluation was being done on Lori Vallo until literally the last proceeding when she was indicted for murder. And all of a sudden, the defense moves to continue the advisement on the grounds that she's not competent to proceed, which we found out a couple days later because they didn't discuss it at the hearing. I'm not sure exactly what the big secret was, but the district attorney said we contest the findings in that report regarding competency of Lori Vallo. Well, Friday afternoon, the prosecutor files with the court a withdrawal of contest regarding 18-211. What does that mean? Very quickly, here it says, the state of Idaho, by and through Madison County Prosecuting Attorney's Office, acting as special prosecutor for Fremont County, hereby informs the court that the state has reviewed the 18-211 evaluation and report of defendant Lori Vallo Dabel and corresponding data provided by the court-appointed examiner with the state's own expert. Based upon said review, the state withdraws its contest to the 18-211 evaluation/report and does not object to the court's determination of competency on the basis of the evaluation. The state further does not object to a medical physician's evaluation and diagnosis of the defendant with a corresponding treatment plan for the purpose of restoring the defendant's competence. So what does that really mean? Obviously, a report was prepared at the request of the court after an evaluation of Lori Vallo. It came back that she was not competent to proceed. The state objected. As the state did in being diligent in preparation for their hearing, they were able to consult an expert. And based upon the state's own expert, they obviously agreed that Lori Vallo is not competent to proceed. What does that mean? It does not mean that she is going home. It just simply means they are going to send her off, be evaluated by a bunch of medical doctors, come up with a treatment plan to restore her to competency so that they can then come back and try her for all of her cases. There must have been something compelling in the report for the state to basically confess the findings of not competent, and now the case is paused as it relates to Lori Vallo. All of her cases are now paused, so nothing will take place on those matters. The Lori Vallo will go off to a state facility where she will not be free, but she will be in custody, and they will try to restore her to competency. How do they do that? Usually drugs, lots and lots of drugs to get people back to being normal again. And what does that usually include? My guess is, and I hate to guess, but based upon what's taken place, the nature of the case, I would imagine that it was some sort of psychosis. And as you may recall, remember this guy, John Hinckley Jr.? Now, he went to trial and was found not guilty by reason of insanity for the attempted assassination of President Ronald Reagan. He was trying to impress Jodie Foster, and he suffered from acute psychosis. Well, that happened back in 1981, and it wasn't until the last year or so that he's actually been released from a facility where he can now live with his mom. And get this, he apparently has his own YouTube channel whereby he puts up songs that he plays and sings, apparently, because he's now competent to proceed. I cannot imagine that it is going to take the state, I would say, more than a year to make Lori Vallo competent again. I have seen cases where people have serious psychosis. And psychosis means is they can appear to be somewhat normal, to have rational conversations, but that everything then kind of comes back around to what kind of brought this all together. And usually it's some sort of crazy stories or beliefs that take place, and they truly believe them. Now, having weird and strange beliefs doesn't necessarily make you not competent, but it can, particularly if you're unable to assist your defense, you don't have any grasp of the evidence against you and believe kind of that everything's going to be okay, and I'm just going to get up and explain everything, that my strange beliefs should make sense to everybody. So that can be a form of psychosis. And understand, I am not a medical doctor. I'm not a PhD psychologist. I don't even attest to play one on TV, but I'm speaking from my own personal experience representing criminal defendants that have been found not to be competent and basically found never to be able to be restored. So we'll have to wait and see if the hearing that was set for June 16th, 2021 will proceed in some manner. More than likely it will. The court could do it all based upon the paper and simply issue an order stating that she be sent to the state facility and be restored to competency, like I said, which could include drugs. And if somebody fails to or refuses to take the drugs, then they can seek court authorization to have them forcefully take the drugs to restore them to competency. Doesn't mean Lori Vallo is getting a free pass. It just means that the whole process is being delayed. The question then will become, if she ever gets back to being restored to competency, will there be a not guilty by reason of insanity defense that could play into her possible defenses? If one is found not guilty by reason of insanity, yes, you are acquitted, but it doesn't mean you go free. It simply means that you are sent to the mental health facility and they will monitor you for the next several decades to see if you are actually a danger to yourself and to others before you are ever released, if at all. It will be interesting to see how long it takes to restore Ms. Vallo to competency and whether the doctors will decide whether she is malingering down there or not. Because everything Lori Vallo says down there, the prosecutors are going to get a bite at it. So it's going to be interesting to see. Now, this certainly begs the question, how will this affect the arraignment for Chad Dabel, which is set for June 9th, which is 2 days from now? Probably not going to affect anything. This is what Chad Dabel wanted, or at least his attorney did. He wanted a separate trial. Now he gets it, and now he's got the perfect defense. This lady and her brother were probably crazy, and now it certainly helps his defense. We'll see how things play out. So let's talk about Chad Dabel. He had an arraignment, and Lori Vallo goes to the state hospital. Well, Chad Dabel entered pleas of not guilty after being formally advised by Judge Boyce in an Idaho courtroom today. He entered pleas of not guilty as the judge asked him how he pled in regards to the counts of conspiracy and murder as to JJ, Tylee, as well as his former wife, Tammy Dabel. There were 2 counts of insurance fraud, not guilty on all counts. The court set June 23rd for a scheduling conference to schedule a trial date. Under the 6-month Speedy Trial Act there in the state of Idaho, they have until December 9th to get Chad Dabel to trial. Now, we're not sure exactly if his now wife, Lori Vallo, would have rather been by his side for an arraignment today, but she is on her way to the state hospital. The court issued an order of commitment. As you may recall, on March 8th of 2021, the court ordered an evaluation for competency as it related to Lori Vallo. Thereafter, the court and the parties received the completed psychological assessment and determined that the defendant was not competent to proceed. The state advised the court that it may contest the findings, and then on June 4th, the state filed its withdrawal of the contest, and therefore the court said, let's send her off to the state hospital to be restored. And the court did make specific findings, basically that the court finds that the defendant lacks fitness to proceed, in that the defendant is incapable of assisting the defense in this case. That makes me believe is that Mark Means was trying to talk about the case, have facts about the case, and she basically, and I've had this kind of situation where a defendant is completely delusional and wants to talk about everything except the case. All right, they want to talk about whatever, but it doesn't get to actually being able to assist in the defense whatsoever. So we'll see if the state hospital can ultimately restore Lori Vallo to competency so that she can then face the charges where she's never actually been advised, because she was found not to be competent when they got to the advisement on the indictment alleging her involvement in the death of her two children, Tylee and JJ, as well as being responsible allegedly for the death of Tamara Dabel, Chad Dabel's former wife. The court made further findings in his order regarding Lori Vallo, and basically said that she is not dangerously mentally ill as defined in the statute, and that basically the Department of Health and Welfare is basically now the provider for the care and treatment at the appropriate facility, and that hopefully that this will take no longer than 90 days. The sheriff was ordered to transport Lori Vallo to the facility, and an evaluation of Lori Vallo's mental condition shall be performed at the time of the defendant's admission to the facility, and that a progress report shall be prepared of the defendant's mental condition. This report shall include any opinion as to whether the defendant is fit to proceed, or if not, whether there is a substantial probability the defendant, Lori Vallo, will be fit to proceed within the foreseeable future. That is huge. That's what we should know within 90 days. And assuming everything goes well in the Chad Dabel case, we'll be rolling right along in the case. So we'll see how this may affect anything in this matter. One final note in the order: if the defendant escapes from the custody during her confinement, the director shall immediately notify this court and the prosecuting attorney and the sheriff immediately. I know that's always a little caveat that they put in those types of orders, but wouldn't that be funny? Once again, another delay in the Lori Vallo Chad Dabel matter. As we know, the matters related to Lori Vallo completely put on hold because she has a field trip. She's going down to the state hospital in Idaho, where she is going to be restored to competency. Chad Dabel, he had his arraignment yesterday. They're going to meet in 2 weeks and set a trial date. But as you may recall, in the tampering with evidence case, we were going to have a change of venue hearing coming up next week. And guess what? That's right. It's been vacated, and they're going to set another date to set another date. Now, I get it. There's multiple cases going on. You have the concealment, tampering with evidence charge, and then you have the homicide indictment. They are closely related with one another, and some sort of motion to join should probably be made sooner rather than later to get them all on the same track. Now, until there is, in fact, a motion to join the homicide case with the tampering with evidence case, these cases are on separate track. So if they're going to have a motion to join filed, they should probably do it sooner rather than later. And the motions hearing regarding the change of venue is more than likely going to impact what happens in the murder case as well. So let's just get it resolved. I like Judge Boyce. He seems like a very good judge. It just seems like we spend a lot of time scheduling dates when the court should just schedule dates. Jobs expand to the amount of time given, and when you have deadlines, it forces people to make decisions. Straight to the docket now. Derek Chauvin wants to question the jurors. That's right. As everybody should know by now, Derek Chauvin was convicted back in April of second-degree murder, third-degree murder, and manslaughter, and he now has sentencing coming up on June 25th. His attorney, Eric Nelson, has filed a motion for a new trial, which is going to be denied. More than likely, this motion for questioning the jurors will be denied as well, because the judge in the case, Judge Cahill, has already ruled on a lot of these issues that are already been resolved. So there's not a whole lot more to do. However, Mr. Nelson is doing his job. And if you do not raise the issue at the trial court level and get a denial of that motion, you cannot appeal that issue for the first time if it was never raised in the trial court. So that's why you see defense attorneys filing motions objecting. If you don't object to the evidence coming in, it's basically deemed waived. You don't have an appellate issue at that point. So you have to object. You have to raise the issues because you can't do it the first time on appeal. So the word impeach, that means to call into question the integrity or validity of the jury's verdict. You often sometimes hear that of a witness. They were impeached, where it basically said, they were questioning the integrity of their testimony. Under Minnesota rules of criminal procedure, a defendant can ask the court for a hearing to investigate possible juror misconduct. And that's what Mr. Nelson is requesting on behalf of Derek Chauvin. And this goes back to an old case from the 1960s, Schwartz v. Minneapolis Suburban Bus Company, where there was an issue regarding the bias of a jury. The court held in that Schwartz case that an inquiry could take place. These type of hearings don't usually take place because once a jury verdict rules, unless you can come up with some hard evidence that maybe somebody was in fact biased, it's very difficult to do so because jurors are not going to come running up to you saying, hey, I'm biased. Well, this case is a little different. As you may recall, several of the jurors went on TV and explained how they reached their decision. And basically, it kind of sounded like they didn't really look at the evidence that closely, but that's their decision. One of the jurors also stated that he had never been to a BLM rally in Minneapolis. He just failed to mention that, oh, by the way, I went to the rally in Washington, D.C. Maybe he answered the question straightforward. However, during the process of voir dire, potential jurors are always asked, if there's something that maybe we didn't ask the right question about, please tell us. I think the fact that maybe you didn't go to a Minneapolis rally, but you went to the one in D.C. may have been something that the defense probably should have been made aware of. I personally think jurors have that duty to disclose that information, and if they don't, the punishment should be on them, which the remedy ultimately would be a new trial. I don't see Judge Cahill doing that in this particular situation, but like I said, Derek Chauvin's attorney has to do this to make sure that he can raise these appeal issues. So Derek Chauvin wants to question jurors, and Chad Dabel will not be a juror. His daughter returned the summons that he received from the 7th Judicial District for the County of Madison, state of Idaho, to appear for jury service. She returned it saying that, well, he's incarcerated and the address that they sent it to is in Fremont County, not Madison County. And by the way, he's in custody. So his daughter, at least she is a very responsible person because she didn't want a warrant to go out for his arrest for not showing up for jury duty. So hats off to Emma Dabel Murray, Mr. Dabel's daughter, who wanted to make sure he didn't get in any more trouble, well, obviously, than he already is. All right. Leave your comments below about all of the stories that we've talked about here today. We'll see you next time on Crime Talk.